2? Is that 1? All right, so let's draw our prize. Maybe it'll be the trip to Glendale. Let's see. Oh, no. Oh, it's not. Let's see. Oh, okay. Frosty the Snowman. Oh, very good. Well, wonderful. And thank you, Jessica. Our next speaker is going to talk to us about changes in tort law. And Michael is a frequent speaker for the CLE. He works in the area of personal injury, wrongful death, consumer litigation. He's written and published in law journals as well, and he also serves as an arbitrator in cases. And here's Michael.
Thank you. I appreciate this opportunity to come and share with you my ideas about what's been going on in Alabama tort law for the last year or so. How many of you have heard my presentations before? Okay. What I usually do is to walk through the principal case law developments and statutory developments, obviously with an emphasis on first impression cases and changes in the law, and then just other cases that may have interesting facts for one reason or another. And I'm going to start with a case, and it's actually on page 43 of your handout, dealing with line and scope of employment, and with some notable facts, and a first impression decision. The employee tortfeasor is actually an FBI agent who has come all the way from California to Redstone Arsenal in Huntsville to take a series of courses to become a special agent certified bomb technician. Now, he's been in town over a month and is staying at a hotel in Huntsville. And while one evening after the program, he's at the hotel on the balcony smoking his Marlboros, and after that day of learning about incendiary devices, he accidentally burns down the hotel. And the Acadia Insurance pays on the hotel's fire loss claim and then files a federal tort claim action under Alabama substantive law for negligence and also respondeat superior, saying he was acting in the scope of his employment, even though the seminar program was over for the day. Of course, the government says, no, that is not in the scope of his employment. The program was over. First impression case in Alabama. And, of course, the test is the employee engaged to perform the certain service, and whatever he does to that end or in furtherance of that employment is in the scope of his employment. Can't be conduct completely personal. Now, the case the court looks at, it's a federal district court decision, looks at some cases with some similar issues in California and Minnesota, and the basic idea, and they agree with the holdings of those cases, the idea being the trip itself away from home is in furtherance, sufficiently in connection with the purposes of employment, and summary judgment motion is denied. Now, going to negligence area, page 5 of your handout, another first impression issue, this Riverstone development case. Case law in Alabama has said that, at least with respect to some negligence claims against professionals, expert testimony is going to be necessary to prove breach of duty and causation. And the question here is, does that apply to negligence claims against appraisers like it does as to claims against doctors, lawyers, engineers, architects? Because appraisers are in a profession that's licensed and regulated by Alabama Real Estate Appraisers Board, and that board has authority to discipline license holders. The court decides this is a profession with sufficient specialized skill and knowledge that expert testimony should be necessary to prove standard of care was breached. Now, was it breached in this case? What were the facts? The appraisers were sued by a real estate development company that had been trying to develop some waterfront property around Lake Gunnersville. And, of course, the crash happened. The development project went south, couldn't pay the mortgage, foreclosure proceedings began. The bank hired these appraisers to assist the bank in formulating the amount of their bid at the foreclosure sale. And they came up with about a $300,000 value. The developer was saying, now, wait a minute, this property is worth about $1 million or so. Y'all have lowballed these figures and favored the bank, and we're stuck with $1 million deficiency. Now, the developer did not have its own expert appraiser, but instead, as we plaintiffs like to try to do frequently, tried to get the critical evidence out of the mouth of the defendant. They got testimony elicited from the defendant appraiser. On the one hand, yes, there are these standards and rules and regulations that you're supposed to be impartial in your value opinions. You're not supposed to favor one side or the other. But on the other hand, also elicited testimony that, yes, our job was to protect the bank. And they argued that constitutes evidence of breach of duty. Protecting the bank, it is tantamount to favoring the bank in your opinion, but the circuit court says, and the Supreme Court agrees, this is not one and the same. That did not get to the jury on that issue. Now, also in the negligence area, page 1, the Bobo case. Now, even though asbestos, the dangers of asbestos, of course, have been known in industry, and there have been a lot of asbestos cases for a long time, there have been relatively little case law development at the appellate level in Alabama through the decades, and this past year there's actually been some that has shaken out and addressed some unresolved legal issues. And one of these, and it's another federal district court case and another Tort Claims Act case, Bobo versus TVA, or United States, based on negligence on the part of TVA. And a major wrinkle in the case is it was the wife of a TVA employee in a what's called a second-hand exposure or take-home exposure case. She was not exposed herself directly to the asbestos fibers in the plant by going into the plant, but rather her exposure happened over the course of 22 years of her husband's employment when she was laundering his clothes at the end of each workday. Now, they submitted evidence that TVA did not follow its own rules and generally accepted rules about limiting exposure to asbestos fibers, and this had the impact of exposing this lady, Ms. Bobo. Now, the TVA argues very vigorously, now, wait a minute, we don't have a duty under Alabama substantive negligence law. The court, Judge Linwood Smith, first impression in Alabama, had tried to certify it to the Supreme Court, and the Supreme Court declined to address the question through certification. And Judge Smith basically analyzed Alabama's, going a long way back, Alabama's philosophical approach in analyzing duty in negligence, and concluded that in Alabama, unlike many other states that had rejected secondhand asbestos exposure, Alabama put a lot more emphasis on foreseeability in deciding on negligence issues and whether there's a duty. In this case, this was actually a bench opinion after a trial. And he concluded, yes, there is a duty in a secondary take-home exposure, asbestos exposure case. Also addressed a first impression issue about the causation standard, and decided that the substantial factor, a more liberal exposure causation test, would apply, and made an award of over $3 million against the government. Now, another interesting thing about this decision, and this is jumping a little bit to the compensatory damages section. This has to do with the medical expense collateral source rule. Now, in these programs, every year for probably about the last 10 years or so, we've talked about where Alabama currently stands on the collateral source rule abrogation, the statutory abrogation back in 1987. And, of course, it was declared unconstitutional in 96, and then in 2000 was declared unconstitutional. So it's back. That statute's back amongst us, kind of a zombie statute plaguing plaintiffs' damages claims. But one question that has been rattling around for a long time is, what does the fact finder do in the scenario where gross amount of medical expenses are this much, but Medicare, Blue Cross, or whoever, pays only this much and the rest is written off? Here, $500,000 medical expense, it was satisfied for about $80,000 that paid by Medicare. And the case from about 3 or 4 years ago, the Crocker case, and now the Alabama pattern charge basically says, okay, the fact finder hears both the gross and the net, and then just decides in the fact finder's discretion, okay, which is fair under the circumstances. In this case, Judge Smith went and agreed with the plaintiff's argument and awarded the full enchilada, the full $500,000, not the net discounted amount. Now, wantonness. For the last several years, since 2007, those of us that do trucking cases and motor vehicle cases and other cases have become painfully familiar on the plaintiff's end with the Essary doctrine, the Essary case that says that was a case from an intersection collision case back in 2007 that basically says that defendants are not expected to engage in self-destructive behavior, and because of that, courts are going to presume against wantonness, where the facts are that the risk to the defendant is as real as the risk to others, such as the plaintiff. Now, been several cases a number of cases, a lot of federal cases that have interpreted that, and one of them from last year is the Griffin v. Modular Transportation, page 7 of the handout. In this case, after dark, in misty rain, an 18-wheeler driver backs the trailer out across a couple of lanes of traffic, and of course, plaintiff's vehicle hits it. Judge Acker, on summary judgment consideration, says, okay, there's 2 explicit exceptions and 1 implicit exception to the Essary doctrine. And this does not apply where there's some evidence of impaired judgment, like alcohol consumption. And the plaintiff here argues the driver was sleepy. He had, the hours of service argument and so forth. Judge Acker says, no, this is not, at least the evidence in this case, not enough to get to that exception. But the other exception is where the conduct is so inherently reckless as to suggest a depravity consistent with disregard of instincts of safety and self-preservation. And Judge Acker says, okay, backing out a trailer across 2 lanes of traffic after dark in wet road, yeah, okay, that makes it. That exception applies. And then also the third exception, which I'm kind of surprised we hadn't seen more in 18-wheeler cases, and that is where the risk of injury to the defendant is not as real as the risk of injury to the plaintiff, because, of course, somebody in the cab of an 18-wheeler generally is not going to be subject to quite the same amount of danger as with a collision in just a little vehicle. But here, Judge Acker turned it on the fact that the cab was not in the travel portion of the highway, but rather the cab was off the shoulder and it was the trailer that was sticking out on the highway. subject to being struck. Now, another wantonness case, a federal case, not in your handout, it only came out December 23rd, the Davis case. It also turns on Exception 2, conduct inherently reckless sufficient. Here, defendant's driver is in a pickup truck, but it's a commercial vehicle. He's looking for a business to make a delivery, but it's a wet road, and it's a cell phone case. He's on the cell phone, evidently maybe trying to figure out the location, and then comes to a sudden stop without a turn signal or anything like that. He gets hit in the rear by another vehicle, which knocks him out into the road where he collides with traffic. Here, the circumstances, the exacerbating circumstances, cell phone use, wet road, court decides, yeah, that makes it for the inherent recklessness exception. And then another twist on wantonness, the 18-wheeler case, Ackers, page 9. Plaintiff, of course, through some discovery, discovers that the truck driver, after the collision, applied for Social Security disability benefits, and his application says, well, I have been very sick for many years, even before this collision, and I have had headaches so severe it would make me pass out. I have insomnia. I have trouble sleeping. And the argument for wantonness, and the court agrees, the driver knew of these potential problems, and they were severe enough that if he had reported them to his employer, he knew he would have been disqualified, would have lost his job, but it's endangering others. So this is enough to put himself at risk and others at risk, and gets to the jury on wantonness. Now, data breaches, a kind of a hot topic, kind of newsworthy. We've all seen a lot of things in the news over the last year or so where big companies that are holding a lot of commercial people's personal data, frequently for credit use or other uses, a third-party hackers or other miscreants get into their files, and then the plaintiff's data is subject to misuse. Got 3 cases we'll talk about very briefly here. The Burton versus Mapco case recognized that there's some new ground being plowed when it comes to what it takes to make out a negligence case against a company like this. Here, some hackers got into Mapco's consumer credit files. Plaintiff tries to file a class action based on his account was hacked, and then unauthorized charges of about $300 shows up. But he was not able to plead successfully that he had to pay that $300, and it's not clear, but evidently it was the Mapco didn't require him to pay it. And the court basically says, from the standpoint of ripeness, from the standpoint of standing, he doesn't have sufficient injury to make out a wantonness claim. Now, second case, Smith versus Triad, a different issue, although it also involves third-party data breach. Here, it's a hospital. They've got patients' medical records stored in an unsecured room. A hospital employee and an unidentified third party break in, steal patients' records, and then a lot of people's identities are used for filing of fraudulent tax returns. Now, here the question is, can HIPAA be used to make out a negligence per se claim? And of course, the hospital, the first thing they argue is, well, wait a minute, we all know HIPAA itself does not provide for a cause of action within the HIPAA statutes. But the court says, and agrees with the plaintiff, well, even so, it meets the criteria for plaintiff using it to base a negligence per se claim on. The class of citizens that it's designed to protect. That fits the criteria. Causation fits the criteria. So the defendant's motion is denied. And then the third one, the Wells Fargo case, Fu versus Wells Fargo. Plaintiffs argue negligence claims, third-party theft of bank's data. They're arguing that the bank was negligent in using unencrypted email that had some sensitive data information. But here, the court says, agrees with the bank, plaintiff could not show causation, and one thing in particular, only one of the plaintiff's identity was stolen, although both plaintiffs were the subject to that or parties in that unencrypted email. Now, shifting to premises liability. Those of us who do premises liability cases have certainly learned over the decades that one of the factors that often make it an uphill battle for plaintiffs is the open and obvious condition doctrine. And then a subcategory of the open and obvious condition doctrine is the darkness rule. What happens when a plaintiff is walking in conditions of darkness? Older cases used to call it the step in the dark rule. And that basically the idea that darkness in and of itself is the open and obvious dangerous condition, and if you choose to walk around in the dark, you kind of get what's coming to you, kind of the underlying idea behind that. The McAllister case, though, page 15 of your handout, helps us understand an important distinction, and that is the distinction between total darkness on the one hand versus dim and poor lighting conditions. This was a fall in a hotel hallway near a restroom, a wet floor, and it was dim light but not complete darkness, and the plaintiff escaped summary judgment. The court reasoning that, as the plaintiff argues, that conditions of dim lightness as opposed to total darkness can mislead a plaintiff into believing that he or she can see and avoid the hazards. Okay, before I get to uninsured motorist topic for just a second, I want to divert to something just a little bit lighter. How many of you have had experience in depositions in dealing with a witness who has been really well prepared by the opposition? Here's an example of some of my own experiences in a deposition, questioning an engineer in Chicago. Question: what was discussed in the Safety Committee meeting of June 4, 1995? Answer: my attorneys reminded me last night that I forgot. And then a corporate executive, after many times when he keeps telling me he does not understand my question. Okay, answer: I don't understand your question, Mr. Roberts. Do you mean, did we plan to terminate your client's contract in October? Question: that's not what I asked. But go ahead and answer your own question the way you have rephrased it. Answer: pause. I don't understand my own question. Now, uninsured motorists, page 15. There's always something new every year about the different cards that the insurance companies and the other parties can play under Lambert and under Lowe. And let me ask you this. How many of you in the last year or so have experienced scenarios where a liability carrier offers their limits and then the UM carrier rejects the offer, refuses to consent, and advances or fronts the money? We're starting to see that a little bit more. Used to never, ever see it. Here, this State Farm case illustrates one of these developments. Court of Civil Appeals. Here, the liability carrier offers its $200,000 policy limits, but the UM carrier, State Farm, refuses to consent and writes its check for $200,000 under Lambert, and then chooses to opt out of the litigation under Lowe. But it goes to trial, and turns out only $90,000 verdict. And it's broken down 80 compensatory, 10 punitive. Now, one question, hey, does plaintiff still get to keep that extra money? And nobody argues that he doesn't, so that's good for the plaintiff. But the question that comes out of this being resolved at the appellate level is, plaintiff says, now wait a minute, of this $90,000, $10,000 is uninsured because the liability carrier's policy has an exclusion for punitive damages. State Farm says, now wait a minute, this is piling on, this is salt in the wounds, et cetera, because it's not, you got more than the jury determined the damages to be, and the appellate court agrees. A plaintiff does not get that extra $10,000 out of the UM carrier. Another case, State Farm versus Pritchard, page 17 of your handout, and this is a first impression decision on the issue of the common fund doctrine in the context of uninsured motorist coverage. And this is another situation, advancing the money. $50,000 is tendered by liability carrier. State Farm has $100 in UM coverage, and they bought out or advanced the $50,000. And the case goes on to trial. This time there's a $400,000 judgment in favor of plaintiff. And then plaintiff argues, and the trial court agrees, State Farm has got to contribute $20,000 toward the plaintiff's attorney fee under the common fund doctrine. And State Farm argues, now wait a minute, we didn't have the same interest. The elements of the common fund doctrine don't apply. Civil Appeal says, well, yeah, it does. State Farm gets a direct benefit. Their interest with the plaintiff is close enough in proving the liability and so forth, and common fund doctrine applies under this decision. Now, Ex parte Alpha, page 16, some variations of these different cards that the parties can play. This is a pure uninsured motorist case. The tortfeasor had no coverage at all. So plaintiff, as his right, starts out the lawsuit, plaintiff versus only insurance company. So at that point, the dynamics would be plaintiff in the courtroom on one side, big insurance company, Alpha, on the other side. But Alpha plays the card of filing a third-party complaint to bring in an insured motorist tortfeasor guy. Of course, they've got subrogation. Then they play the card, I want a realignment, so that the uninsured motorist tortfeasor is realigned with us as a defendant. And then, hey, well, we want to opt out. So at that point, now it's only plaintiff in one corner, and for all the jury knows, poor Mr. Old tortfeasor by himself in the other corner. And then they take the position that not only they can opt out, but they can furnish Alpha lawyers to defend the tortfeasor. So plaintiff says, now wait a minute, this is just too much. There's a conflict because you still have got that subrogation claim. You hadn't given up the subrogation claim, Alpha's subrogation claim against the tortfeasor. How can you furnish a lawyer? And basically the court says, plaintiff, that's not your problem. If it's okay with the tortfeasor, if he waives that conflict, so what? So that can happen. Now, moving to mid-mail, first impression decision, the Vanderwall case, page 19. Well, not really first impression, but overruling a line of prior cases. And that is the question of, does the Alabama Medical Liability Act govern and control even sexual molestation claims? The facts that here were, lady plaintiff goes for physical therapy. The physical therapy goes far beyond the bounds of what physical therapy is supposed to be. And then as it turns out, or she strongly suspects, or I think there's even other cases that have been filed involving this same therapist and this same physical therapy facility. So plaintiff patient tries to engage in discovery, and of course immediately they invoke 65551 of the Alabama Medical Liability Act, which prohibits any kind of other acts discovery. Plaintiff argues, now wait a minute, let's go back and look at the line of, let's overrule this line of cases represented by Mock case and the O'Rear case about sexual molestation being covered by AMLA, and the court says, okay, we'll agree with that, and overrules Mock and overrules O'Rear. So now molestation, sexual molestation, even when it happens while medical treatment is going on, is outside the AMLA. Now, of course, the court also kind of throws it aside. Of course, we also observe that most liability policies for medical providers will exclude coverage for health care professionals who sexually assault their patients. Now, products liability, page 26, Collins versus Duvall. And this is a question of whether under implied warranty, a medical device, first impression, medical device is considered a consumer good. Now, first of all, think a minute. Why would a plaintiff bother with an implied warranty claim under a medical for a personal injury when he's got AMLA available to him, or negligent design, negligent manufacturer theories available? A couple of reasons. Typically, one is wouldn't apply here, but one is there's no control defense for a warranty claim. Second, it can be a solution to a statute of limitations problem. If it's a consumer good, then you've got a 4-year statute of limitations, not a 2-year statute of limitations. But here the facts were a surgical patch was inserted in 2004 in the patient's abdomen, but it did not malfunction. It did not cause an injury until 2012. Plaintiff says this is a consumer good, so the statute of limitations does not start running until the injury. There's a distinction. Commercial good, statute of limitations starts running at time of delivery. That is, when that surgical patch got inserted into the abdomen, even though it was working perfectly fine and plaintiff had no idea that years later it was going to mess up. But the court says, okay, this is not a consumer good. It is it's commercial. Therefore, the statute ran long before plaintiff knew that he would. The warranty claim ran long before plaintiff knew that he had a problem. Now, going to fraud, and this is kind of a borderline fraud products liability case. Wyeth v. Weeks, page 29 of your handout. A case that got a lot of publicity. The Supreme Court answered a certified question from federal court, and that is, does Alabama law recognize fraud claims against a brand name drug manufacturer where the plaintiff is injured by a drug made by a different company, the generic version of the drug? And you might say, well, how on earth could that be? How could a different company that didn't even make the drug be liable? And the answer is, and the Supreme Court concluded, for a misrepresentation claim based on the warning labels, in the rather unique situation where the FDA does not allow, and federal law does not allow a generic drug manufacturer to come up with their own different warnings than what the brand name manufacturer had originally come up with after the tests and what they were supposed to disclose to the FDA and all that. Because of Alabama's particularly robust, going back to what we talked about in the Bobo case, foreseeability principles, it's actually fair, even though it's a minority position in the country, for the brand name drug manufacturer to be responsible. Now, This ruling was mentioned in the Wall Street Journal with great gnashing of teeth and so forth, and the Alabama legislature quickly rode to the rescue. Now, the Alabama legislature does not always act quickly and decisively on things like funding the courts or things like that, but where multinational drug companies were subjected to potential responsibility for coming up with bad warnings, they can move pretty quickly. In substance, basically, they quickly passed a statute that said that, in substance, to paraphrase Joe Pesci's opening statement in My Cousin Vinny, everything that Supreme Court just said is BS. Now, also in fraud, the branch banking case, page 27 of your handout, is an illustration of the court's current position about the impact of the statute of frauds. Several years ago, the statute of frauds, of course, that requires certain promises to be in writing, only impacted contract claims, and then beginning with the Bruce v. Cole case in the early 2000s and the Holman case, the court began expanding its scope to other fraud cases, to fraud theories, and then also to other tort cases. Now here, this branch banking case, $12 million verdict, where the jury had agreed with borrowers, again, real estate developers, where things went south, that the bankers had promised that we're going to, the note is, it's going to come due in, such and such time, but we're going to roll over the interest, and the payment is, we're contemplating payment to be coming out of sales of the real estate. The jury decided that was fraud, but the Supreme Court takes the verdict away and says statute of frauds bars this claim. The borrowers were unsuccessfully arguing that, well, there was enough paperwork to meet the elements of satisfying the statute of frauds. There was some memos about repayment anticipated for future development. The court said no, not enough, no mention of interest being carried forward, and the essential terms. Now, going to bad faith, an important decision, page 32. Now, we all know that when it comes to your most common bad faith types of cases, your first party bad faith cases, the vast majority of the times that the appellate courts or federal courts look at the question of, has the plaintiff satisfied the element of absence of debatable reason, plaintiff loses. It's a very tough standard to come up with, because it doesn't have to be that great a reason. It doesn't have to be ultimately a successful, viable reason, but if it is a reason, that knocks down a first party bad faith case. Now the question here, though, is what about the other species of bad faith, this negligent or bad faith failure to settle claim, third party type, where the argument is the insurance company negligently or in bad faith failed to failed to act on an opportunity to settle a case within policy limits, and then the policyholder gets hit for a verdict in excess of the policy limits and so forth. The Franklin case deals with this important question. Is the absence of debatable reason an element of that kind of claim? The underlying facts were a fairly typical car wreck in that the plaintiff's hit from the rear, but the defendant's arguing plaintiff pulled out in front of me, that's why I hit him in the rear. $50,000 limits, but the plaintiff was paralyzed. And there were some limits or some offers with deadlines imposed by plaintiff's counsel, offers to settle within policy limits filed before, submitted before suit was filed. Insurance company said, no, we've got this argument about contrib. We don't need to pay policy limits. Suit was filed, and then somewhere along the way, insurance company says, well, on second thought, yeah, here's the policy limits. At that point, plaintiff says, too late. Goes on to trial, ultimately $9 million verdict affirmed without opinion by the Alabama Supreme Court. Now, the underlying defendant assigns rights to the plaintiff, and together they sue the liability carrier. And they say, well, we've got a trump card because of that contrib argument. And it's an element of a third-party failure to settle case. But the federal district court goes back, and there are actually relatively few cases, Alabama appellate cases or federal cases, that analyze really what it takes to make out a failure to settle case. And the court concludes that, except for one Schulte decision where there's some little dicta to the contrary, the standard is a totality of circumstances test, not debatable reason being, a element absence. It's got to be shown. So, the plaintiff in that case survives summary judgment. Now, outrage. March versus Best Buy, page 41, federal district court case. It's a case where plaintiff, a young lady, is an employee of Best Buy. She had stored naked photographs of herself on some of her personal electronic devices. She had some trouble with the hard drives and took them in to the Geek Squad, which is a subdivision or a department of Best Buy for technical support and so forth. And of course, I'm sure you can all see what's coming. The photographs were inappropriately copied and viewed by the geeks. She sues for outrage. And of course, Best Buy says, well, wait a minute, plaintiffs hardly ever get to the jury on tort of outrage because it's almost never outrageous enough. And in this case, it's not outrageous enough. And you can't show, plaintiff couldn't show sufficient mental suffering. But the court says, actually, this does survive summary judgment. It is one of these very rare cases where that happens. Now, another line and scope case, Church's Fried Chicken, or rather Cajun Operating Company, page 44. The question of whether a Church's Fried Chicken employee was acting in the line and scope of his employment. A customer comes in to Church's Fried Chicken, Church's Chicken. They get into a discussion about the quality of the cuisine at that particular establishment. There is a serious disagreement, a frank exchange of views, and the employee takes one of those metal straw containers, it's a lot heavier than those straw containers out there, and bashes the customer in the face with it. Now, first thing, in the assault lawsuit, first thing Church's says is that is outside the line and scope of this employee's work. We have never instructed or authorized our employees to hit people with metal straw containers. We highly disapprove. But this actually gets to the question, the distinction between authority and agency on the one hand versus line and scope in the context of torts on the other hand. And it's a broader, the scope and reach of scope of employment standard is broader than agency. And in this case, because the genesis of this disagreement had to do with the food, the court said, okay, yeah, that gets to the jury. The Court of Civil Appeals says this gets to the jury. Of course, I suspect that had the discussion arose from a disagreement about whether Donald Trump's views are correct, different result. Now, also in compensatory damages area, page 48, I think we've probably all experienced how antsy auto insurance companies or other liability insurance companies can get about making sure hospital liens get put to bed when the cases get settled. And this Alpha versus University of South Alabama case is an example that sort of helps explain that. And this Alpha gets tagged for a $30,000 hospital bill because of a screw-up in how it paid a $2,000 MedPay check. The hospital filed a $30,000 lien, and then after that, Alpha sends the $2,000 MedPay check directly to the parents of a deceased patient instead of sending it to the hospital. Now, the court, and then after that, the hospital files an amended $36,000 lien. Now, summary judgment is granted for the hospital on the $30,000. And the Alpha argues, well, this is just so, this isn't right, and we want to overrule Progressive, which had held that you can be tagged for a greater amount than what you pay if you are infringing on a hospital lien. The court did not overrule that, but they did agree with Alpha's argument that they're stuck for only $30,000, not the $36,000 of the amended lien that happened, that was filed after they sent the MedPay check. Now, also in compensatory damages, page 51, Fluker, one of the things we remember from law school, and that us plaintiffs like to talk about a lot, the eggshell skull doctrine. You take your plaintiff as you find him, but it's very rare you actually see that talked about in those terms in case law. But this Fluker case does talk about it and does express that. And this is kind of interesting. It's a pro se claim, federal tort claim again, where a veteran was injured when somebody's pushing his wheelchair in a VA hospital, and then after the leg injury, his leg winds up having to be amputated. Government argues, now wait a minute, it's because of his years and years of smoking cigarettes that he has a diminished blood supply. That's really the underlying reason why his leg was so badly injured it had to be amputated. And the federal court denies summary judgment to this pro se plaintiff and says, the eggshell skull doctrine applies. It's if the tortfeasor inflicts a graver loss on the victim than what would otherwise be the case because of a pre-existing condition, you take your victim as you find him. Now, commercial damages, lost profits damages, page 51, a business case, Ding versus Scroggins. Plaintiff Scroggins was a sales rep for Mr. Ding's lighting equipment company. He comes up with an idea for an LED light, and they have some discussions about, hey, this could turn into a really good idea. Scroggins' evidence is that Mr. Ding promised and agreed and represented that if a patent application is ever made on it, even though it was Scroggins' idea, and Ding filed the patent, Scroggins' name would be on the patent. Now, ultimately they part ways, and then it turns out Mr. Ding gets a patent on it. It does not include Scroggins. He files suit, gets a $500,000, or gets a total of $3 million verdict. And the case, the Supreme Court says it properly went to the jury on the fraud claim, but the plaintiff failed to establish damages sufficient for the business losses. And what the plaintiff tried to do was based it on opinion testimony, admission, kind of testimony where the plaintiff essentially says, Mr. Ding and I were talking about this, and we both said and agreed that this is worth millions. The value of this product is worth millions, and we can make a lot of money on it by selling it to Walmart. But the court wound up concluding that that is not sufficient evidence to satisfy the reasonable certainty requirement that established by the super value cases and its progeny from back in 87. Now, another case on lost profits damages, the Dupree case, page 52, a Cherokee County motor vehicle accident. Plaintiff is a television producer working, he's riding his motorcycle, and he's in Cherokee County filming a program called Trash to Treasure that has to do with, with sort of these reality show things that we see all the time on TV, where they go around to yard sales, these mega yard sales. He was working on that. They had just begun filming the show, doing a little bit of filming, and when he was hurt, and the project halted. Now, of course, the defendant says, now you cannot show a profit loss because you had not sold this project to anybody. You had not sold this show to anybody. And the plaintiff, in this case, unlike the other case, had an expert, a business practices expert who helped to support the question, helped to support plaintiff's claim. His business model was in line with previous efforts where he had successfully sold his show to companies. Now, this next case, we're getting close on time here. I'm on a couple of cases here. This one is kind of one of these big red flag cases, City Court Flats case, page 57. Now, how many of you have ever filed a complaint or seen a complaint filed where the filing fee is not paid up front, but the plaintiff files an affidavit of substantial hardship? In this case, a wrongful death claim is filed right before the statute, and court costs are not paid at the time of filing. One of these affidavits is filed, but the trial court does not enter an order approving this until long after the statute has passed, long after 2 years is up, or sometime after it's up. But in the order tries to make it retroactive, the court says that doesn't count. That does not constitute a filing. So a big red flag on filing, using that device to file. Now, kind of interesting. How many of you have had cases where the issue of foreign law had an impact, or potentially had an impact, or was an issue of an argument? Either the question of a tort, the lex loci delicti principle for torts. I always keep thinking of Superman's nemesis when I hear that phrase. Or a contract that specifies Delaware law or German law or something like that. Now, late last year, there was a major development in that somebody in the legislature became concerned that circuit judges in Alabama would be overcome with an irresistible impulse to start applying Sharia law to Alabamians, and make our Alabama women wear burqas and things like that in the hot Alabama August heat or whatever. And so, like in that other case, the legislature quickly rode to the rescue and quickly addressed this imminent danger, and not just passed a statute, but a constitutional amendment that provides for Alabama, no Alabama court shall be required by contract entered into by any person or entity to apply or enforce any foreign law, including now. And of course that was on the ballot, and of course Alabama voters, are they going to vote against something that says anti-foreign, passed readily? So this is now the law, and I suspect that this may have some unintended consequences. It's these commercial cases or tort consumer cases where there's choice of law written into the contract. Some of these principles here, like that we see, may have some interesting results that may be different than what we're currently seeing under previous law in Alabama. A pair of nursing home cases, I'll just hit these very quickly, page 58, help understand where we are on the issue of where a nursing home resident with some impairment of cognitive abilities, and then there are arbitration agreements signed by relatives at the time of admission. They die because of alleged nursing home negligence, personal injury, personal representatives of their estate file wrongful death claims. The Troy Health case, page 58. The nursing home resident had a diagnosis of alcohol, persistent dementia, and altered mental state. The question was he competent at the time that he had signed a durable power of attorney that appointed one of his daughters, who later signed an arbitration agreement? And bottom line is, the court said evidence was not sufficient here to show that this resident was permanently incompetent at the time that he signed the power of attorney, so arbitration was upheld. Now, the Diversicare case, in this case, the personal representative actually is successful in avoiding arbitration, even though the personal representative is the same person who signed the arbitration agreement. In this case, different facts, major important different facts about the patient himself. Here, the patient was a 21-year-old son of the personal representative who had been profoundly mentally retarded and incapacitated his entire life, so he never had any capacity whatsoever to grant any authority, and he was an adult. The mother who signed the arbitration agreement never held any official capacity of conservator, guardian, and of course couldn't have a power of attorney. And bottom line was, and the court analyzed, there's some important language here, analyzed several cases dealing with this. Bottom line, the test is if the deceased nursing home resident would have been bound himself or herself to an arbitration agreement if he had signed it, then so would the personal representative, but in this case, he couldn't have been because of his mental incapacity. Now, that pretty well exhausts the time I have here for the program, and are there any questions, either now or at the break, or if anybody would like to ever just call me or brainstorm with me on email or telephone, I'm certainly happy to do that. Thank you.
Well,